Hi, my name is Mayor Katz. I practice appellate law and I'm an adjunct professor at the University of Maryland, Baltimore County. I have published several law review articles relating to issues of federal practice and have been involved in litigation that implicate interesting questions of civil procedure. Many students, and even a lot of law professors, think that civil procedure is rather boring. It is, they say, just a bunch of rules that you have to memorize and then forget as soon as you get out of the class because you can look all the stuff up later anyway. I couldn't disagree more with the general premise. Well, talking about joinder isn't as exciting as abortion or the right to burn crosses or American flags. Civil procedure is tremendously important and really makes a lot of sense once you've given it some thought. The objective of the federal rules and other doctrinal issues covered in a civil procedure course is to design a fair and neutral legal system. Without a fair and neutral legal system, adjudicating questions such as flag burning would be far less productive because the rules wouldn't allow for a fair consideration. I believe that the interests in fairness govern all, or nearly all, of the Civ Pro course. I call this the fairness rule, and will refer to it several times during my lecture. Now, it turns out that creating fair rules is very difficult. This is why the rules of civil procedure are so complicated and may seem arcane at times, and sometimes they are arcane. Consider what we're trying to do. We want a system that is fair to the interests of the plaintiff, the defendant, third-party observers, third parties who are not yet in the case but will be in the future, district court judges, appellate judges, states, the federal government, and the federal system at large. That's a lot of interests. The rules do a pretty good job, I think, trying to get all of those interests together in one place. They don't always get it right, but ultimately, I think, do a pretty good job. As we go through all of these rules, yes, maybe arcane rules, think about how they maximize fairness given all of the competing interests. Doing so will make your study of civil procedure more interesting. It will also help you to remember all of these rules and make more sense out of them as you go. We're going to start with three areas of civil procedure that grow more out of case law and constitutional law than the federal rules. They are personal jurisdiction, subject matter jurisdiction, and the Erie Doctrine. We will then move to pleading and the structure of litigation. As we go, I will try to give you hypotheticals to help ground our discussion. But because Civ Pro questions are notoriously complicated, you really need to see them in writing to be able to do them. As such, my focus will be to clarify doctrinal issues and give you the tools that you need to do more complex hypotheticals on your own. Listen carefully, if need be, listen several times, and I think you'll find this lecture quite helpful.